resolve the impending chaos when a person dies intestate. Through this video, I, Gayatri Sharma, will enlighten the viewers about what intestate is, what are the legal provisions for it, and what happens in different conditions of an intestate death. The Indian Succession Act came into operation on 30th September 1925, and it seeks to consolidate all Indian laws relating to succession. It has no retrospective operation and is applicable to intestate and testamentary succession. Testamentary succession involves a scenario in which the deceased has left a valid will for the successors, which expresses the transfer of properties to people of his preferences. And an intestate succession involves a scenario in which the deceased has not left a will or an enforceable will for the successors. Now, when an applicant or an heir wants to make a claim on the assets of the deceased, then he requires a letter of administration or a succession certificate issued by the court. The letter of administration is a document or an instrument in which a competent authority mentions the distribution of assets among the heirs, and a succession certificate is granted to the person who wants to inherit debts, securities, and other immovable assets of the deceased. Under intestate succession, the principles of asset management and distribution are based on the personal laws which differ between religions like Hindus, Muslims, and Christians. Whenever a person before dying makes a will for only some estates and leaves the rest, or whenever a person makes an invalid will, shall be delegated under the laws of intestate succession. Hindus, under the Hindu Succession Act of 1956, also clubs the succession process for Buddhists, Jains, Sikhs, and Arya Samaj. The state law has provided a list of successors or four different classes who will be eligible to be granted with the assets of the deceased person. If a probate court procedure is essential, then the court will choose someone based on the list of those four classes. But it should be noted that each and every state has a different set of priorities based on different religions. Most states grant the surviving spouse or registered domestic partner as the first claimant, followed by adult children, which is then followed by other family relatives. Muslims have different personal laws for Shias and Sunnis. These laws are governed by the Mohammedan law, in which the sharers who inherit a specific share of the property and residuaries who inherit the remainder of the property can make a claim. If sharers and residuaries are deceased, then the distant kindred will entitle the property. And Christians follow section 32 of Indian Succession Act of 1925, in which widow or widower receives one third share. Also, balance is given to the lineal descendants, which includes each child or children of the predeceased with equal share. In case there are no descendants, one half is taken by the widow and the rest of the balance to other relatives known as kindred. Under Christian line of succession, the assets are consolidated under two types of properties, which are immovable property and movable property.